Imagine this. A brand new nation, celebrating its liberation. The president, this icon, grants a huge act of mercy, a mass pardon.
A really symbolic moment.
Exactly. But then that very act, that compassion, it gets challenged in court. Not for being too soft, but for being, well, discriminatory.
That's almost contradictory, doesn't it?
It does,
Yeah.
but it really happened, and it sort of tested the absolute foundations of this new democracy.
And it ended up setting a massive precedent, really defining how power would actually work under this new constitution.
So today we're doing a deep dive into exactly that scenario. It's a landmark South African constitutional court case from 1997, President of the Republic of South Africa, and another v. John Phillip Peter Hugo.
A really pivotal case.
Our mission really is to unpack how South Africa's highest court grappled with the president's huge power to pardon versus the fundamental right to equality.
That core tension.
Yeah. We'll get into the tricky legal arguments, the court's reasoning, which might surprise you, and why this case is still so important for understanding constitutional principles for, anyone interested in law, but also just for figuring out what a just society looks like.
It's a fascinating glimpse into how a nation really builds its legal identity piece by piece.
Okay, so let's set the scene. It's 1994. South Africa is just electric, with the promise of this new era.
A time of huge change.
And our central figure here is John Phillip Peter Hugo. He's a man serving a pretty long sentence, 15.5 years.
Right.
And his personal life had already been, deeply affected. His wife had passed away, which left him as the sole parent to their young son. The son was born in 1982, so he was under 12 when this key presidential act happened.
And that act itself was genuinely historic. May 10th, 1994. Nelson Mandela's inauguration day.
The very same day.
Yeah. He issues Presidential Act number 17. And look, this wasn't just some minor rule change. It was a sweeping act of mercy.
A big gesture.
Huge. Granting special remission of sentences to certain categories of prisoners.
And the categories were quite specific, weren't they?
Very. It included anyone under 18, all certified disabled prisoners, and this is the absolute key bit for our story, all mothers in prison on 10 May 1994 with minor children under the age of 12.
Right, mothers with young children.
Right.
But importantly, it also excluded certain people.
Absolutely crucial point. It specifically excluded prisoners convicted of really serious offenses, murder, rape, child abuse, aggravated robbery, things like that.
Okay.
But here's the twist for John Hugo. He was a father, the only parent. Under the strict terms of that pardon, if he'd been the mother of his son, he'd have qualified. He'd be walking out.
Wow.
But because he was the father, he was excluded, left in prison.
So what did he do? He challenged it.
He did. He took it to court.
Yeah.
His argument was that this presidential act violated the equality rules in the interim constitution that was the governing law at the time. He basically said, look, this unfairly discriminates against me because I'm a man, because of my gender, and sort of indirectly, it discriminates against my son too, because he's still deprived of his only parent.
And how did that first court react?
Well, the initial ruling from the Durban and Coast Local Division actually went Hugo's way. Justice Majed looked at it and said, yes, this is discrimination on gender grounds.
Okay.
And under the Constitution, such discrimination was presumed unfair, so the judge presumed it unfair and actually ordered the president to correct the act.
That's quite something, isn't it? Telling the newly inaugurated Nelson Mandela, this icon, that his first big act of mercy was legally flawed.
A very bold move, yeah.
But that lower court decision, it kind of blew open an even bigger question, right? A really fundamental constitutional one.
Exactly. This stopped being just about John Hugo. It became about the limits of presidential power itself.
These powers, the power to pardon, historically, they were almost like off limits to courts.
That's right. Historically, the president's power to pardon, which came from Section 82 of the interim constitution, its origins, were these things called royal prerogatives.
Ah, right, like the queen or king's powers.
Exactly. Think of the powers the English monarch used to have. Vast, almost unquestionable authority. These got adopted into South African law over time. And for ages, the thinking was that courts just couldn't review them. They were seen as beyond legal challenge, acts of sovereign power.
So the massive question for the Constitutional Court was, even for someone like Mandela exercising these historic powers, was he truly immune from legal challenge under the new Constitution?
And the Constitutional Court's answer, in this really groundbreaking finding by Justice Goldstone, writing for the majority, was a definitive no.
No immunity.
None. They ruled that all presidential powers, even the ones that came from those old royal prerogatives, were now absolutely subject to the interim constitution and its Bill of Rights. Full stop. This is a huge shift.
Why was that so significant?
Well, what's fascinating here is how the court just explicitly laid it down. In South Africa's new constitutional setup, no government power, it doesn't matter how old or where it came from, stands above the Constitution.
The Constitution is supreme.
Absolutely.
Yeah.
Section 4 said it was the supreme law, binding everyone, legislature, executive, judiciary, including the president. The president leads the executive branch, so he must follow the Constitution. It directly answers that question you raised. How do you build a real constitutional democracy if some powers are sort of sacred cows, untouchable?
You can't.
You can't. The court said basically those days are over.
And this wasn't totally out of the blue globally, was it? Other countries were moving this way.
That's right. It wasn't happening in a complete vacuum. You saw a similar trend in other canon law countries.
Yeah.
The UK had a famous GCHQ case back in '84, which started to chip away at the idea that all executive powers based on prerogative were totally unreviewable. New Zealand, Australia, Canada, they were also moving towards more judicial oversight of these kinds of powers. Even in the U.S., where the president's pardon power is famously broad, it's not completely beyond scrutiny.
But there was something particularly strong about the South African position.
Yes, the crucial difference highlighted by the court was that the South African Constitution, unlike, say, the English approach, which evolved more gradually through court decisions, mandates judicial review. It says courts always have the power, the jurisdiction, to check if presidential acts are constitutional.
Always.
Always. Now, the grounds for actually striking down an act might be limited in certain cases, depending on the type of power, but the door to the courthouse is never locked. That was a foundational statement. The rule of law applies to everyone, right up to the top.
Okay, so with that massive principle established presidential power can be reviewed, the court then had to get back to John Hugo's actual complaint. Was this specific discrimination unfair?
Right. The focus shifts.
The president's team submitted evidence. Right. Affidavits explaining the thinking behind the pardon.
Yes, including one from Mrs. Helen Stark, who is with the SA National Council for Child and Family Welfare. And the president's core rationale, as stated, was this deep concern for children who had been deprived of the nurturing and care which their mothers would ordinarily have provided.
So relying on that common idea.
Exactly. We're relying on the general societal understanding, or perhaps assumption, that mothers are the primary nurturers and caregivers of young children. He also mentioned, needing to consider the integrity of the justice system and public worries about releasing too many prisoners. So it seemed like a mix of compassion and practical concerns.
And this is where it gets really, really tricky, isn't it? Because the Constitution's Equality Clause, in Section 8, doesn't just ban discrimination. It has this presumption.
Section 8.4, yeah. It creates a presumption that if discrimination happens on a listed ground, like sex or gender, it's automatically presumed to be unfair.
Which puts the burden on the government, right?
Exactly.
Yeah.
The state then has to step up and prove that actually in this specific context, the discrimination was fair.
So what really stands out to you about how the court navigated this idea of fairness, when you've got what seems like a genuinely good intention, an act of mercy driving the president's decision?
Well, it's that classic tension, isn't it? A seemingly benevolent act running up against the strict demands of equality. The majority, Justices Goldstone and O'Regan concurring, they acknowledged something really important up front.
What was that?
They explicitly said that the generalization itself, the idea that mothers bear the main burden of childcare, is actually a root cause of women's inequality in society.
So they saw the problem with the stereotype.
They did. They recognized that this very stereotype has historically boxed women in, kept them in domestic roles, excluded them from public life. So they weren't naive about the problematic nature of the generalization itself.
But then there's a twist.
But then comes this really subtle but incredibly important turn in their reasoning. They argued that in this specific instance, the discrimination didn't impose a disadvantage on women. Instead, it afforded an advantage early release from prison to a specific group, mothers.
So it was giving a benefit, not taking something away or imposing a burden on women generally.
Precisely. And the impact on fathers, like John Hugo. The court found it was not unfair in this context. Why? Because their imprisonment stems from their convictions, their own past actions, not from the Presidential Act.
The act didn't put them in prison.
Exactly. The act merely denied them a benefit early release to which they had no prior legal right or entitlement anyway. And crucially, the court said this denial didn't fundamentally impair their rights of dignity or equal worth. Being denied an unearned benefit didn't attack their basic dignity as people.
Okay, I see the distinction they're drawing. Were there other factors?
Oh yes, practical considerations weighed heavily. The sheer numbers. Releasing all fathers with young children. Remember, male prisoners vastly outnumbered female prisoners, like 50 to 1 back then.
50 to 1. Wow.
Yeah, we're talking maybe over 100,000 men versus under 3,000 women, releasing potentially tens of thousands of men all at once. The court felt this could cause considerable public outcry.
Undermine faith in the justice
Well,
system.
potentially, yeah.
Yeah.
Undermine public confidence. So they argued that using the blunt acts, these broad categories, was arguably necessary for such a massive, unprecedented act of clemency, even if it wasn't perfectly fair to every single individual like Hugo.
So summing up the majority view.
In a nutshell, the majority concluded the presumption of unfairness was rebutted. The discrimination in this very specific, unique context, a post-liberation act of mercy aimed at children, was deemed fair. It was a complex balancing act between the president's compassionate goal and the practical realities.
But what makes Hugo so fascinating, and frankly such a great case to study, is that even though the final order upheld the President's Act, the judges didn't all agree on how to get there, did they?
Not at all. It's a real masterclass in judicial reasoning and disagreement. It shows how smart legal minds can look at the same set of facts, the same constitutional principles, and come to really different conclusions or take different paths to the same outcome.
So who disagreed and how?
Well, first you had Justice Didcot. He actually dissented on a more procedural point. He didn't think the court should even be deciding the fairness issue at all.
Why not?
He argued the case had become abstract, academic, or hypothetical. Basically, the pardon had already happened. The mothers who qualified were already released. And by the time the case reached the Constitutional Court, Hugo's son was likely too old anyway.
So no practical effect anymore.
Exactly. For Didcot, there was no live controversy, no practical purpose in the court making a ruling. It was, in his view, moot.
Okay, then there were judges who disagreed strongly on the core issue of fairness.
Yes. Justice Kriegler wrote a powerful dissent on fairness. He agreed with the majority that the president's power was reviewable by the courts. No question there. But he fundamentally disagreed that the discrimination was fair. He argued that relying on that primary caregiver stereotype, even for a good cause, was wrong because it perpetuated harmful patriarchal views.
How so?
He felt it damaged all women by reinforcing these limiting societal roles. For Kriegler, things like the president's good faith or the practical worries about public outcry were just irrelevant to the constitutional question. Was the discrimination unfair under Section 8?
And for him, the answer was yes.
A clear yes. He believed you needed an exceedingly persuasive justification to allow gender discrimination, and the state hadn't provided one here. He felt the Constitution's goal was to actively dismantle stereotypes, not lean on them, even inadvertently.
That's a very different perspective, and there was another important voice, Justice Magoro.
Yes, Justice Magoro. She agreed with the final order upholding the President's Act. But her reasoning was completely different again. A concurrence, but on distinct grounds.
Okay, how does she see it?
Like Kriegler, she actually found the discrimination was unfair. She agreed that denying fathers release based on these stereotypes infringed their dignity and reinforced harmful gender roles. She specifically noted the Constitution should help us move away from gender stereotyping.
So if she found it unfair, how did she end up agreeing with the final decision?
This is where she brings in another part of the Constitution, Section 33, the General Limitations Clause.
Ah, the clause that allows rights to be limited under certain conditions.
Exactly. She viewed the Presidential Act as a law of general application. And then she asked, was the limitation it placed on the right to equality reasonable and justifiable in an open and democratic society?
And her answer was?
Her answer was yes, it was justified. She weighed the legitimate goal helping children affected by parental imprisonment against the practical realities. Releasing all fathers was potentially unmanageable, and doing individual assessments for thousands was likely impossible in that context.
So it was a pragmatic choice for her.
It seemed to be. For her, the effective choice the president faced was either some children get united with a parent or no children get united. Faced with that stark choice, she found the unfair discrimination was, in this specific instance, a justifiable limitation on the equality right, given the significant benefit to those children who were helped.
Wow. 3 distinct paths, unfair but justifiable, unfair and unjustifiable, and fair in context.
Exactly. It really highlights the complexity.
So let's pull back. What does all this mean for us, for you listening? What are the big takeaways from this deep dive into the Hugo case?
Well, first and foremost, Hugo really carved it in stone. In South Africa, no one is above the Constitution, not even the president, not even performing an act of mercy on day one.
A fundamental principle.
Absolutely.
Yeah.
It established that all exercises of presidential power, whatever their history, are subject to constitutional review. That was huge for a young democracy defining itself.
And what about equality, especially gender equality?
It profoundly shaped how the courts approached the Equality Clause. It showed that understanding fairness isn't simple. It requires nuance, looking at context, impact, history, societal realities, especially when dealing with past disadvantages.
It's not just about treating everyone identically.
Not always, no. The court had to grapple with whether treating mothers and fathers differently in this specific pardon scenario actually advanced or hindered the broader goal of equality. And as we saw, judges disagreed sharply on that.
And the role of the court itself.
I think the different judgments really showcase the Constitutional Court's crucial role, navigating these intense tensions between broad policy aims like helping vulnerable kids and fundamental individual rights. Even when the right being impacted, like Hugo's right not to be discriminated against in receiving a benefit, might seem less severe than, say, the right to liberty itself.
It shows the intense debate needed.
Intense debate, rigorous analysis, careful balancing all essential for interpreting a living constitution in a way that respects both dignity and the practical needs of governing.
So we've seen how this act of presidential mercy, meant to bring families together, sparked this incredibly deep constitutional debate. Equality, judicial power, the very meaning of fairness in a new democracy.
A powerful illustration of the challenges you face when trying to build a genuinely just society from the ground up.
And it leaves us and you with something to think about, doesn't it?
Definitely. That provocative thought. How often do we rely on societal generalizations, maybe even with good intentions, to define roles or allocate opportunities?
Like the mothers as primary caregivers idea here.
Exactly. When does relying on such generalizations cross that line into unfair discrimination? And perhaps more controversially, could there ever be times when using such a generalization, however imperfect, might be seen as a justifiable step towards some greater good, as some of the judges argued here?
What stands out to you about the court's different lines of reasoning in this case?
It's a tough ongoing challenge, isn't it? Building a truly equal society. And these complex legal decisions like Hugo, they continue to shape that path, forcing us all to keep grappling with these hard questions of fairness and justice.
Absolutely. Well, thank you for joining us on this deep dive.